Going.
All right. We're here with Patty McGinnis. She's running for the 435th District Court. And John Works from Montgomery County Tea Party with Ms. Pat Tibbs, Dennis Tibbs, Bob Bagley, Del Fessenden, and Larry Rogers. As we discussed, we'll go ahead and turn it over to you for up to 5 minutes of it.
Thank you. My name is Patty McGinnis. I'm running for judge of the 435th District Court here in Montgomery County. I'd like to thank everyone here for allowing me the opportunity to speak with y'all tonight and also to entertain questions. I'm a resident of Montgomery County. I've been a resident since 1997, and I live here in South County area in White Oak Estates with my husband Chris Lovett and our 2 children, Luke and Eli. They both attend CISD schools. My husband is a hardwood floor guy. He has his own business here in the county. He also works a second job as a manager at Spring Carpets. I've been employed by the county. I was a prosecutor with the District Attorney's Office, also with the County Attorney's Office. My service to the county was approximately 12 years, while at the same time I also was a municipal judge in a local municipality for 6 years. I love Montgomery County. I've enjoyed my time here tremendously, and I hope to further serve the county by being your judge for the 435th District Court. The 435th District Court is just that. It is your court. And for quite some time, it was actually shut down. Although we did have a judge in that court, and we were paying that judge. The 435th District Court was created for a sole purpose, which was to handle sexually violent predators. That program was basically torn down, and it is no longer active. And at the same time, or close to the same time, your board of judges, your local board of judges, also removed all felony cases from Judge Seiler's court. And so my motto is correct, protect, and respect. CPR. I'd like to bring life back to the 435th District Court because your tax dollars are paying for it. And I hope that you will allow me the opportunity to have the court work for you. Thank you.
Okay. Great, thank you. Okay, let me start off. In question, well, and you alluded to this a little bit in your opening, and in question number 2, your 3 primary goals that you want to be measured by. In your initial response is the reason you're seeking the bench is because the current judge is persistently and willfully violating judicial rules and Texas Constitution. And you alluded to it, you know, throughout the questionnaire. So let me let you expound on that a little bit. You know, what happened, you know, with the current judge? What did he violate? Why was he sanctioned? And what motivated you to go with that, taking that information to run from that perspective?
Certainly. The Texas Judicial Commission, if you're not familiar with this organization or the group, it's not just judges policing judges. There are also citizens on this organization, and they are duty-bound, if you will, to inspect or investigate any challenge or grievance that comes in front of them about a sitting judge. In this particular instance, I believe an investigation was launched, and I believe they thoroughly looked into it, and they have 3 different, I guess, types of recourse. They have a private reprimand, a public reprimand, and then an action in which they could actually try to remove a judge. And I personally don't know of one of those happening. Specifically in our county, I'm not familiar with a public reprimand in the past. So to understand where I'm coming from, When you see a public reprimand of a judge in an existing judiciary that I don't know has ever had one, and then you take the reason for the reprimand, and that's where it really kind of hit me. If you've ever sat on a jury panel, it's very intimidating. You have 60 or 70 people in a courtroom that don't know each other. And their job is to answer truthfully questions that are asked by the court or by the lawyers to see if they are fit to serve as a juror. In one instance, one of these individuals who was there on the veneer panel actually stood up and said, I don't, or something to the effect of this, I don't believe this guy can get a fair shake here. I don't believe he can get a fair deal in this court. And for me, that struck home. I've been part of hundreds of jury selections.
Yeah, if that's right with you. And we can just take out 2 of mine.
Okay. Now, and for that gentleman to stand up and actually say that, he had to have felt very passionate about what he saw happening. And he directed his comments to the bench. He directed his comments to the judge, to Judge Seiler. And for me, I was actually kind of, my legal career, I was raised in this courthouse up here, okay? I've appeared in front of almost every judge up there, and some that are deceased and retired as well. That hit me in the gut, that a member of our community who was there serving as a potential juror, felt strong enough to say, wait a minute, this is not how the system's supposed to work. So that's really what motivated me to run, along with the fact that, we're talking about sex offenders. Nobody likes a sex offender, right? We can all agree on that. And I'm no different in that camp, probably. However, we're also talking about witnesses. There were witnesses that came to testify. They were under subpoena. They were there to do their job and testify. And there were just horribly demeaning and insulting comments made to these witnesses. So imagine if that's your job, if you're a doctor and you're called to testify in court, and then a judge looks at you and says, you must just have a 3rd grade education. No one should be treated like that in a court of law. It just shouldn't happen. So, and to me, that's kind of common sense, Judges have training, they go to school. So if you don't have that common sense, I can guarantee you somebody told them you don't treat people like that at the beginning. So correct, protect, and respect. Correct, I will do things correctly. I've done it in the past. I have judicial temperament, I've exercised it, and I know how to conduct a court. Protect, you want to protect the rights of every person that enters the courtroom. Defendants, victims, staff, potential jurors, witnesses, they deserve that. And respect, I have respect for the judicial system. And it's very dear to me. And so I was really, I read that reprimand probably 18 times. And finally I just said, I'm not going to sit and whine about it. I'm going to get up and try to do something.
Describe the qualifications and experience that make you the best candidate for this office.
Past judicial experience for sure. I know that some people will say, oh, well, you were just a municipal judge, so you were night court, you handled traffic tickets, or you handled truancy. And that is all very true. However, I don't think a lot of people think of this. For many people, their first experience with our judicial system, or their first experience with the court system, is in a municipal traffic court. So I took that to heart in the sense of, we'd have juries, we have jury trials at night, sometimes we have 3 a night. We had multiple defendants come through, sometimes young offenders with their parents. And when they came into the courtroom, what I wanted them to experience was the actual system working. And I wanted them to have the same respect for it that I had for it. And so if that's their first exposure to that system, then it may just be a municipal court, but the courts run the same way. The rules are the same, the procedure is the same, and you want it to work. Because these people that come for jury duty at municipal level, or the offenders that come for a speeding ticket, those are also the same people that vote. Those are also the same people that go up to Conroe to sit on a capital murder. And so you want them to have a good experience, because I want them to participate in our system. So past judicial experience definitely is one reason. I have served in the capacity as a prosecutor and a defense attorney. I think that is crucial because from both of those perspectives, I think I really understand the court system in the ways that we could be more efficient. I've also worked at the jail. Okay. I've worked the night shift intake at the jail, so I've actually been there when people are being booked in. I know the impact that if you're not running the court efficiently, that's a problem, because people are sitting in that jail day after day, and we are paying for that. So that's another reason that I believe that I'm experienced. I'm a small business owner, and I think that is very important because I know what it takes to actually run a business. And I'm not suggesting that our court is a business, but if we're being realistic about it, the efficiencies or the lack of efficiency costing us all money. So it kind of is in that perspective. You know, the bottom line is I'm competent. I'm competent and I'll follow the rules. And you won't have people trying to recuse me, and we won't be paying for visiting judges to come sit here cases that the judge that you've hired should be hearing.
Okay. So who all is running for this position?
Just me.
You and
me. And you know, as far as Judge Seiler, I don't know that he's not officially filed yet, but I certainly feel that he will be running.
But you know, a lot of judges do rely on case law, and I wonder why would any judge go to case law, which is somebody else's interpretation of the law or the Constitution, rather than make your own? Why would you go to case
help
law?
me explain your question to me, just so.
Well, if you're making a decision on some case and there's some precedent, I don't know if it has to be exactly related or loosely related, why would you rely on the ruling from that other court rather than just go to the root document, the Constitution or the statutes, and make your ruling yourself?
If the Constitution applies to the issue that is being brought, then certainly that would be the document to go to. Now, you also said statute. For me, in criminal law, the statute will be controlling first and foremost, because that's the burden that the state has. They have to prove beyond a reasonable doubt each element of the offense. And those are clearly listed in the statute, okay? The only time that I would see case law being an issue is if there's a specific point in the case. A lot of times you might see that with a search and seizure issue, where the Constitution speaks directly to that, but there might be some subtle nuances that are fact-specific that will lead you to the case. And the case is only going to apply if it's on point.
Yeah. It seems like a lot of things like Supreme Court rulings, 100 years ago, some court ruling was based on a previous court's ruling, and then the next year or two they did it again, so the errors just seem to get amplified, and some rulings that come out don't seem like they're related to, or judged on the Constitution. They're judged on this series of erroneous rulings.
So you're talking precedent.
Yeah.
Relying on precedent. Well, I believe that you should rely on precedent. I don't believe I should be legislating from the bench at all, and I don't believe that I should be making new law on a daily basis. Now, there are times when you have to make new law, when the existing is pretty bad, but that is rare. That should always be the exception. always,
So it seems like the default is that a judge would say, the last person that ruled on this had to be right. And so I'll just start there,
Well-
like zero-based budgeting, instead of going back to the beginning, I'll pick up at this point.
I don't necessarily agree with that. I think that, because it really has to be on point to apply. So there may be case law, there may be Jones v. State that talks about a dog sniff. But how they got the dog there, and how the dog alerted, and the reason for the stop, all of those issues could be very different than the case that you have in front of you. Does that make sense what I'm saying?
That'd be pretty closely related.
The term that we use is on point.
Yeah,
And I can tell you, there's not a lot on point usually.
really.
Can I steal a little bit of your time just to follow on that?
My bad.
Because you had said that sometimes you have to make law. What is that? What is that name? I know your answer.
You have no choice.
What does that mean that you sometimes would have to make law?
You probably have seen a few examples of that recently, I believe maybe in the 9th District Court. So that's an example of what it
Ninth
is.
District Court here?
Mhm.
Okay, give me an example.
Where you just say an issue comes before the court and they say, well, I don't agree with the case law, I don't agree with the Constitution, I don't agree with anything, I'm gonna tell you this whole law is unconstitutional. And they kick it out, or kick it up, so to speak. I don't believe that should be the norm. The norm.
Should it ever be? Why should it ever be?
I think it has to be
Skipped you this time.
drastic, you have to have drastic fact patterns that the government has really just broadened or tightened, tightened their grip on the people, and that shouldn't happen.
So I can
So,
see,
that's where that protect comes in. When it's time to protect the rights of the people, that would be an example to me.
okay, so I can see him kicking something out because it's unconstitutional, but if you're making new law, aren't you kind of circumventing what the state legislature would be, should be doing?
That's how the whole online solicitation, that went up, and they said, okay, this is just talk on the internet, and so they revamped the statute,
Right,
right?
right, okay,
That's an example of what
right,
I'm talking about,
okay.
of making the
Sorry.
law.
It's okay.
We're done, that was the time.
Yeah.
No, it's your
Oh,
turn.
your time's over.
Your time's-
Sorry.
I spent all my time getting here.
I should have brought skip cards and handed John the next two turns.
You already had it with your turns.
We have a problem in Montgomery County with elected officials not fulfilling their duties, let's put it that way. We have judges as well as others that get paid a good amount of money and put in less than 40 hours a week. Some of the courts are closed on Fridays and many other times. Are you planning on doing this full-time, and are you gonna be there 40 hours a week, or are you gonna be expecting your personnel to work and you not be there, or how are you going to run your court?
I plan to be there full-time, and I have to calculate the years here. The last 6 years is the first time that I have not worked 2 jobs. I was full-time with the county as a prosecutor, and I not only put in those hours, but for police officers, when I was preparing for trial and they didn't get off shift till 10 p.m., I would invite them to my home to prepare for trial at the end of their shift and make myself available. I did ride-alongs in the evening, so I'm not going to be a less than 40-hour worker, if that's your question, for sure. And certainly in the judge role, you have the night hours that are included, and I think that they should be counted If you have officers at your door at 2 a.m. to review a search warrant and go over those things, certainly would make myself available for that because that's an essential part of the job. But I don't plan to have the court dark and locked up throughout the week. No, I'm a worker.
Okay. Well, my next question goes back to your answer.
Can I interrupt you 1 second? I
Okay.
apologize. But because I want to touch on something that you said, and if you picked up on my questionnaire, you probably know how I feel about this. You had a question about networking. And should that be, I guess, time be given for elected officials to be networking? I'm not speaking for other elected officials, but I am speaking for judges in the sense of my philosophy. I don't believe that there's a need for judges to network. You know, when I'm in docket right now, working, and judges leave the bench early to go to a lunch, to either shake hands or to talk, it really, really is very frustrating to me. So if that helps, because that's something that's kind of dear to my heart.
Okay, going back to question number 5. U.S. and Texas Constitution are the living documents. You're very clear that they are not living documents. But I didn't see a clear understanding or answer to the second part of that question. Please answer in the context of progressivism versus originalism. And that really is kind of a logical follow-on to that little dialogue we had just a couple minutes ago about inventing new laws or whatever.
I don't believe the judge's job is to invent new laws or to create laws from the bench. We have the U.S. Constitution, we have the Texas Constitution, and we have statutes. The statutes are, for the most part, very clear, and when they're not, you can defer if you need to case law. The Constitution, the Texas Constitution, I feel as though are there for a purpose, and I'm not, my intent and my job is not to circumvent it by any means. And when it is a resource for a case, it should be the first and foremost resource that you use. I don't know if I can, I'm not a...
Well, give me examples of when it's not a resource for a case.
Well, it depends on the issue of the case. So there are some issues that come up, for example, hearsay, okay?
Okay.
A lot of hearsay in the case, right? And we have numerous exceptions to hearsay. And so we have rules of evidence that specifically address those exceptions. Excited utterance would be an example. I'm not going to be able to go to the Constitution to get an answer on making a ruling on the admission of a particular hearsay statement. But I can go to the rules of evidence. And then, what 9 times out of 10 will happen, both sides will bring you case law and say, well, Judge, but here's why it's an excited utterance. And the other side, but here's why it's not an excited utterance. My job at that point is to sit down and read whatever they provide me, number one. And if I'm not satisfied at that point, what I should be doing is doing my own research to make that ruling. And that'd be an example where I'm not gonna defer to the Constitution, but I am gonna defer to the actual statute, the rules of evidence, and to the case law. I mean, those are the real life issues that really come up. You know, I've tried a lot
Everything's
of...
black and white.
Yeah.
Sorry?
To the uninformed, everything is black and white. I'm speaking of myself.
Yeah.
So it's easy for me to say one way or the other,
Right,
but you're clarifying.
Yeah, and I'm not gonna, in actual cases, in actual trials, the things that come up are, I don't wanna call them mundane, because they're not to the people that are sitting in that room, you know, that are litigating an issue, but they are not glamorous and exciting, and we have to dive straight to the Constitution, because normally it's more something like, well, we really want to get this in front of the jury because they said this. And the objection is, but that's hearsay. Well, you're right, it is hearsay. okay, let's see, does it meet an exception? Because you don't, you're the gatekeeper. You're the gatekeeper of what comes in front of that jury.
Right.
And I have a very good understanding of that, and I understand the importance of it, and I know that I have to be diligent in being the gatekeeper.
Okay, thank you, Larry.
Give me just a breakdown on your experience percentage-wise being a prosecutor versus being a defendant.
I'm not a defendant, right?
No.
I haven't been a defendant.
Defense attorney.
I was a prosecutor for a little over 12 years. I prosecuted misdemeanors and felonies. My positions I was a chief prosecutor in the county attorney's office of a county court. I was a chief district court prosecutor in the DA's office. I was also in a supervisory capacity as the section chief of the whole misdemeanor section itself. I worked on many of the things that are now in place. The jail intake, where we actually housed a prosecutor at the jail. I helped develop that program. I also spearheaded and initiated the Friday jail dockets. We used to bring inmates over every week to a county court from the jail, a busload into the county courts to dispose of their cases. A lot of those inmates had felony cases, and so their misdemeanors weren't getting disposed of, they were just being reset. And so we kind of had a group meeting and a plan, and we said, let's do a jail docket. So I met with Sheriff Gage, and we actually constructed in the back of his jail a courtroom, and we got a bench, and I met with the county clerk and the judges and got it on board. So now every Friday there's a jail docket, so we're not transporting inmates back and forth just for them to sign a piece of paper to go back to the jail.
So the other side of being a prosecutor, how many years?
As a criminal defense attorney, 5. A municipal judge for 6, and a prosecutor for at 9 during that time.
So basically, one of my big questions is, as we go through other courts that we're interviewing, is if you're a prosecutor for 12 years and you're defending people for 5 years, how do you separate when you become a judge and not lean one towards the other?
That's a fantastic question. And for me, it's in the past proven to be very easy. The 6 years that I did with the municipal court, I don't have an explanation for you as to why it was easy, but there's such different roles. And if you understand the role and you're competent, you can fulfill that role. The neutral place on that bench is just so very important for the system to work. And I just have never had a problem adapting to that, because it really is a ball game. And my only job is I'm not supposed to help the state, I'm not supposed to help the defense. I call the balls and the strikes, and I keep order to the game. It's just something that I've been able to do in the past. I'll tell you this, and I don't know if it adds to that, but for me, as a prosecutor, I've appeared in front of a few very state-oriented judges. And when you're standing there and the court is trying to help you, I kind of got sick, because I thought, why are you doing this? I've got it. I don't need the help, And same thing from the defense perspective. I think for most lawyers, regardless of what side they're on, when they're in a case, they don't want that help. They want to do their job. And I know that's how I felt as a prosecutor, and that's how I feel as a defense attorney, and I know that's how I felt as a judge in the past.
Okay, we're about 30 minutes into it, so it leaves us with just over 15 minutes to keep going around the table.
We're gonna skip on John, right?
Yeah, skip on, yeah.
What is the single
You
most?
said you
I had
remember.
three questions.
Yeah.
I got a
What's
bunch.
the single most
I'm
important
pulling
action
executive.
this county needs to do to keep the great community it is?
You know, I saw this question and I tell you, I was really, tell me what number that was again, because
10 in it.
Yeah.
I was really stumped on that question because of the word single, for one thing. I think we do have a great community, and this goes back a little bit to the question posed earlier about the hours that you would keep in the courtroom open and along those lines. And it also goes back to, I guess, maybe the road bond issue a little bit. Everyone that we have voted into office, they are, in my opinion, first and foremost, should be public servants. And it seems as though, for some, not all, but at some point, a sense of entitlement happens. And it's really, really sad, personally, because for many of these elected officials that are currently sitting now, I've known them for 10 plus years. And when I see that change, that this is mine, I own this, it's sad. So my response to your written question that you just asked, I would like to see that go away. I would like people to run for office, and if they are elected, I would like them to serve, to really serve. And that means it's not about them. That position, whether it be county attorney, whether it be a judge, whether it be commissioner, it's a title. And instead of owning that title and wearing that title as though they are the end-all be-all, I would just like to see them serve. And that means that they are going to listen to the people, and they're going to get in and really try to experience what the people are experiencing. An example of like the jail. There's all the talk about we need a new jail, we need a new jail. I would venture to say that most of the people claiming, hey, we need a new jail, they haven't been a part of this process to see other areas that maybe could help that problem at the jail. Does that make sense what I'm saying?
Oh, yeah.
I would just like them to serve. I would like them to serve and not, I don't want self-promotion. That's not what I want to see. I want to see people kind of, I guess maybe cross-training. Getting in and watching a docket and watching a defendant go through this process and through the jail and then saying, oh, okay, so here's what's happening over the court. Maybe we got a clog over here, maybe that's why they're